So I'm being told the live stream is now on and we're now in session. Thank you very much, everybody. And for this final, which is being streamed live on YouTube, I'm very happy to welcome the teams from MIS and from Singapore Management, who have throughout the competition, like all the other teams, shown exceptional knowledge, exceptional hardworking advocacy, and exceptional collegiality towards the other teams. So I have the great honor now for this final usually the occasion of the final of the Moot is a happy occasion, but we are living in very different and difficult times. So a final in a competition dedicated to the peaceful resolution of international dispute is almost an act of defiance against what is going on in this world. And for that, I introduce Funke Adekoya as presiding arbitrator of this tribunal. She is I would say, preeminent Nigerian lawyer, exit annulment committee member, and also a very lovely person, as are they all. Then for the claimants appointed arbitrator, I welcome Lucy Reed, professor of law, president of SIAC, and the presiding arbitrator of the very first tribunal that I appeared before 19 years ago. So, which I think was your first one as presiding arbitrator, may have been, perhaps. So we all go back a long time. And respondent appointed arbitrator Claudia Anaka of Decade. And we also crossed swords in the past on a case which I think is still live, which is kind of scary and contrary to, dispute should be resolved speedily, etc. Anyway, for today's final, none of the three ladies will be themselves, even though you should address them by their own names, not by the names in the case study. They will ask questions which are not in any way indicative of their personal opinions, positions, etc. So any challenge to them on the basis of a moot final is by definition doomed to fail. They also have explicit instructions from me to be mean and brutal and cruel to the teams in asking you questions. That is not or is not their nature. It's in fact against their nature. They're all extremely nice and measured arbitrators in real life. So with that kind of list of warnings and other things, I have the great pleasure to hand over to Funke for the final. Oh, sorry. No, actually, I'm the tribunal secretary, and I nearly forgot to ask the administrative preliminary matters. So claimant and respondent, have the teams agreed on the order of issues, other than that we do the challenge first, and the allocation of time? Claimant, please.
Hello, everyone. It is an honor to be here today. Well, I will first go with an introduction of my team, if that's okay, and then talk about the allocations. My name is Mahtab Javadi, and I will be addressing issue number 2 on behalf of the claimant today, along with my co-counsels, Mr. Amir Mahdi Dehqan and Ms. Mehnoush Janbakhsh. And we will be assisted by Ms. Zahra Khati. We have discussed with the respected respondent in this regard, and we did not reach an agreement over 2 issues. It is respondent's request that they go first on all 4 issues. However, we would like to go first on issue number 1 and issue number 3. Therefore, we left it for the respectful tribunal to decide. And lastly, about time allocations, for us, we shall reserve 9 minutes on issue number 1. 1 minute for rebuttal, 11 minutes for issue number 2, 1 minute for rebuttal, 10 minutes on issue number 3 and 1 minute for rebuttal, and then again 11 minutes for issue number 8 and 1 minute for rebuttal. I suppose the respectful respondent has a different time allocation from now on, I ask them to represent their time allocation to the respectful tribunal. Thank you.
Greetings to everyone and members of the tribunal. My name is Justin Lai, and together with my co-counsel, Mr. Keith Toh, we appear on behalf of the respondent. And we would propose that the respondent goes first for all issues, given that we are challenging jurisdiction. As for time allocation, I'll be taking 11 minutes for issue 1, and 1 out of those 11 minutes will be reserved for rebuttal. And for every other issue, we will take 10 minutes and have 1 out of those 10 minutes reserved for rebuttal.
Madam President, as to the order of appearance, would you like to make a decision or leave that to the Secretariat?
I think that in real life, the arbitral panel would actually have a discussion on it, but in these circumstances, I would leave it to the Secretariat.
So by the power illegally delegated to me by the President of the Tribunal, I decide that claimant should go first on C1 and on 1 and 3, and respondent should go first on all the other issues. And I will also be the timekeeper, assisted by Catalina Bisek, who has acquitted herself very well throughout this week, as everybody knows. Madam President, with that, I hand back to you.
Thank you very much, Secretariat. Can I now ask the parties to start with addressing the tribunal on the challenge to the arbitrator? We have read the challenge and we have read the response to the challenge, and we'd like to hear short oral argument in support of the challenge and opposing the challenge.
Madam President, apologies. May I clarify that you want to hear the entirety of the arguments relating to the challenge to Mr. Kudris right now?
Yes, we would.
Okay, much obliged.
And I should clarify that as that arbitrator, I will listen, but of course I will not interject.
If I may begin.
Please do, we're waiting for you.
My apologies, Madam President. Wasn't the issue stated by Madam Secretariat that the claimants go first on issue number 1 and 3, and for the respectful respondent to go first on the rest, or yes, is it your decision to go otherwise?
No, we start with 8, and you did not request to go first on 8. We start with a challenge.
Okay, my apologies, please.
Madam President, members of this tribunal, good day to you all. As introduced, my name is Keith Toh, and I appear on behalf of the respondent. I will now address you on the issue concerning the challenge to Mr. Kudris as arbitrator before the present proceedings. Now, Article 15.1, read with Article 8 of the ICSID Additional Facility Rules, allows for a party to call for the disqualification of an arbitrator for, inter alia, a manifest lack of ability to exercise independent judgment. And this has been accepted to include both a duty of independence and a duty of impartiality. Now, our position is that Mr. Kudris ought to be disqualified as arbitrator from the present proceedings because the current facts raises justifiable doubts with regard to his impartiality. Now, at the outset, we want to point out that Mr. Kudris has a duty to disclose his participation in both the present proceedings as well as the Welser proceedings. However, he has failed to do so, and in fact, he continues to fail to do so for reasons known only to him. Now, while we are not saying that this ought to be determinative, we are saying that this should be a relevant consideration taken into account by this tribunal as a factor weighing in favor of finding that he at least shows an appearance of impartiality.
Counsel, could you please explain to the tribunal why you feel that the opposing side's suggestion that the documents in the other proceedings should be disclosed to you would not solve the issues of some sort of imbalance in terms of the knowledge available to the rest of the panel?
Madam President, respectfully, we would say that firstly, there is no legal basis for the claimants to seek record disclosure from both proceedings and have the records of both proceedings shared to all or both tribunals. And the only way that this sharing of record would be possible is if they obtain the consent of all the parties here. Now, not only does Spain not agree to the sharing of the records in the present proceedings, we note that the claimants have failed to even get the consent of the Welsers family too. So we first say that this option should be dismissed on this grounds, but furthermore, Madam Arbitrator,
Is the lack of consent of the Welser family on the record?
No, Madam President, but at the same time, the claimants have failed to establish that the Welser consent is indeed present on the record. And in any event, Madam President, we would say that this option is still unsatisfactory. Now, insofar as it may go to cure any information asymmetry, it does not address the real issue here, which is that there is a manifest risk of prejudgment on the part of Mr. Hughes. And I'll go on to address why there is a manifest risk of prejudgment later. But first, let me tell you why. Another reason why the sharing of the record would be an unsatisfactory option to us, the respondent. And this is because of a very simple reason. The evidence that they seek from the Welser proceedings should be protected by banking confidentiality. And this is something that the respondents take very seriously because it draws, or rather it raises issues of national security. Now, on this basis alone, we say that the Welser record cannot be shared to the present tribunal and to the Fugger family. Furthermore, as I mentioned earlier, Madam President, there is a strong, or rather a very serious issue here of a manifest risk of prejudgment on the part of Mr. Hughes. Now, such a manifest risk of prejudgment arises where there is a significant factual and legal overlap between the two proceedings. And if this overlap gives rise to an appearance of lack of impartiality, we say that a manifest risk of prejudgment can be found, and accordingly, Mr. Hughes should be dismissed from the present proceedings. Now, first, it is our position that there is significant factual overlap between the two proceedings, and that such facts are relevant to the determination of the legal issues in both proceedings. Now,
for the benefit of the tribunal, could you just highlight one area of overlap?
Certainly, Madam President. Now, the similarity in facts can be seen from how both disputes concern a common party, being the respondent Spain, and both claimants in the present proceedings also are in the same industry, being that of loans, or rather banking lenders who loan to the respondent Spain. Furthermore, both parties in these proceedings are complaining of the same events. If I may refer this tribunal to page 3 of the case study.
We've seen that we are at page 3.
This tribunal will see that the Welser family was also affected by the same 1557 default as well as the 1560 settlement, which gives rise to the present claims brought by the Fugger family. Thus, we say that the complaints and the facts in both proceedings are exactly the same. Now, the similarity does not stop there. This is because the Fugger family have brought their claims, or rather they are complaining of breaches of the CCC. Now, the Welser family are also relying on this exact same bilateral investment treaty in order to found their claims. Thus, on this basis, members of the tribunal, we would say that there is a sufficient and significant overlap in both the facts and legal issues in both proceedings. Now, second, it is our position that such an overlap in the facts and the law give rise to an obvious lack of impartiality on the part of Mr. Kyrgios. Now, in the ICSID case of Karatube and Kazakhstan, the tribunal held that an arbitrator cannot reasonably be asked to maintain a Chinese wall in his own mind, as his understanding of the situation in one proceedings may very well be affected by his knowledge derived from the arbitration proceedings separate to the present proceedings. Now, given the significant overlap between the facts and law in the Welser claims and the Fugger claims, we say that despite his best efforts, Mr. Kyrgios may unwittingly make a determination in favor of one party as a result of being privy to external information not in the record of the present arbitration. Now, for example, he will be hearing the arguments from both sides, and essentially he will be hearing 4 sets of arguments, 2 claimants and 2 respondents. Now, insofar as it comes to a position of law, say whether or not the Salini test applies, he will have whatever he decides in one proceeding will definitely affect his decision in the other. Now, in this way, his judgment cannot be said to be completely independent or impartial, as it will naturally be colored by what happens in the parallel proceedings. On this basis, Madam President and members of the tribunal, we say that there is a manifest risk of prejudgment on the part of Mr. Kyrgios, and accordingly, we kindly ask this tribunal to dismiss him from the present proceedings. Now, Madam President had earlier queried about the possibility of the sharing of the record, and I had already addressed this tribunal as to why such a possibility is simply an unsatisfactory option for the respondent here. And I also note that the claimant have proposed another possibility, which they say would cure any risk of impartiality. And we say, and this suggestion put forth by the claimants is that of appointing the same arbitrators in both proceedings. Again, our position is that such an option is simply unsatisfactory. First, it is a fundamental principle of arbitration that parties should be allowed to appoint whoever they so please as their own arbitrator. Now, insofar as the claimants want to appoint the same arbitrators in both proceedings, this would deny the respondent of such an option. And we say that this breaches the principle of equality of arms. Second, the Welser Tribunal has already been appointed. Now, insofar as they have already been appointed, what the claimant is essentially asking is for the entirety of the rest of this tribunal to be dismissed so that Mr. Kyrgios can remain on this tribunal, and that we should appoint the same arbitrators in the Welser proceedings to the present proceedings. We say that this is simply an unreasonable request because it is so inefficient. Instead, the simpler position would be simply to ask the claimants to dismiss Mr. Kyrgios before the present proceedings, and accordingly, we say that the challenge should be upheld. Now, members of the tribunal, I note my time, unless I may address any other concerns this tribunal may have.
Now, Mr. To, could you briefly address the timing of this challenge? You are aware under Article 8 of the additional facility rules, any challenge needs to be made promptly. Could you very briefly address that requirement and how it is fulfilled in our case?
Certainly, Madam Annika. Now, we do note that Article 34 of the ICSID Additional Facility Rules requires parties to bring any challenges promptly. However, we say that there is no express specification as to the number of days within which proposals for disqualification must be brought, and instead the promptness inquiry must be assessed or ascertained on a case-by-case basis. And this was held in the 2007 ICSID case of Suez and Argentina. Now here, we say that the challenge is brought promptly. Now, insofar as the first letter sent by King Philip is concerned, we note that the respondent has a plausible justification for why it was delayed, and that is simply that the letter was lost at sea. Now, the tribunal may then query as to why this first letter does not contain any challenges to Mr. Kyrgios' arbitrator. Now, we say this is simply because King Philip was not yet advised as to his legal position in this regard. Now, in fact, it is stated at page 14 of the case study there that the moment King Philip duly retained counsel, he sent a follow-up memorial containing more detailed arguments. And in this follow-up memorial, he does set out the challenge to Mr. Kujas. And in any case, we do not know when this second letter was sent, but we do know that it was received very quickly after 15 August 1564. And we say on this basis, this tribunal should find that the promptness requirement has been satisfied.
Thank you.
This is my submissions on issue 8.
Thank you very much. In the absence of any other questions, I would then ask for the response from Claimant's Counsel.
Thank you, Madam President. Members of the tribunal, esteemed colleagues, good day. As mentioned before, my name is Mehrouche Jean-Marche, and along with my co-counsels, we represent the claimants in today's proceedings. In the next 11 minutes, I will be discussing issue 8 on part of the claimant, and I reserve 1 minute for rebuttal. Members of the tribunal, I will be mirroring the arguments raised by the respectful counsel for the respondent, and in this regard, I will be discussing 3 major points and 3 major issues. The respondent puts forth first that there has been, and there is, in fact, an overlap of the facts of the case, and 2, the overlap of the facts and laws of the case could result in a lack of impartiality. And lastly, they address the claimant's suggestion for a de facto consolidation in case of existing issues. Members of the tribunal, Madam Arbitrator brought up the matter of timing, and in that regard, we will push aside this matter first, as it has to do with the format, just to ensure that we can have a relevantly smooth pleading. Members of the tribunal, we do not disagree that the respondent has in fact put forth its challenge to the arbitrator in time. It is in fact mentioned within the exit rules and the exit drafting history that there isn't a specific time in which a party would have to absolutely put forth a challenge. And this is fluid and has to do with the timing in which a party becomes aware of the potential for the challenging of an arbitrator. And thus, we're not in disagreement at all with the respondent regarding this specific point. Moving on to the rest of the issues, the
Counsel,
yes.
Do I take that to mean that you have no complaints as to the timing of the jurisdictional challenge?
Not at all, Madam President.
Thank you.
Thank you. With regards to the first point brought up by the counsel for the respondent, the counsel for the claimant has to ask, what standard is the respondent putting himself in way of? Within the exit convention and within the IBA additional facility, within the exit additional facility rules, there are 2 general sets of standards that have been subject to scrutiny through the years since 1966, a higher standard and a lower standard. The respectful respondent first argued, and I quote, the challenged arbitrator must at least show an appearance of impartiality. But then it moved on to argue that there is a manifest risk of prejudgment and a significant overlap of the facts of the case. Now, this wording and the wording that the respondent used is specifically of importance because we must clarify under which standard are we taking into account these facts of the case? Is it the reasonable third party's point of view, or is it the manifest lack of the qualities that we're observing? these standards, as mentioned before, have gone up and down again throughout the years and have not stayed the same. They've gone through a roller coaster of situations, first starting with the Amico Asia case, in which the standard was quite high. And then right after the Amico Asia case, the standard of reasonable third person's point of view became into question. Now, the standard has never been the same throughout the years. And the arbitrators have argued for either side on multiple levels and in multiple situations. We argue that under the high standard and under the low standard both, Mr. Kujas does not show that they have, in fact, shown impartiality that would push the tribunal to set them to the side. Members of the tribunal. If we do look into the arguments made by the respectful counsel for the respondent, we can see that they argue that the evidence within the case is one that is similar to the Welsers case. They argued first that they are both, the disputes both discuss the same respondent. Second, that they are within the same industry. And third, that they are and the matters of the case are the same. And we do not argue that the subject matter of this dispute could potentially look similar, but there's a difference between the subject matter of a case and facts and legal issues of a case. In the Iran Claims Tribunal, this matter was discussed and brought into attention. There's a difference between subject matters being the same and facts and laws being the same. Yes, the subject matter is the same. The Welsers have engaged in activities similar to the Fuggers. They have given loans to the emperor, and they have been shorthanded and had been subject to heavy debts. That is a true fact. But at this stage of the proceeding, we cannot possibly know that these facts would overlap in any shape or form, as we do not know what the Welser claim actually entails. We do know that the Welsers were subject to the 1566 states of the empire. We do know that they settled or presumably settled with the empire, but we do not know what their claims is and what they are actually bringing before the tribunal. And this was a fact that was mentioned by Madam President. What are the similarities of facts and law that overlap so greatly that has pushed the respondent to argue that the cases are factually and legally the same? And how has the respondent decided at this stage of the proceeding that the facts overlap? This was a matter that was discussed widely in the PIP case. In that case, Professor Fadallah was subject to the challenge made against him at a very early stage in the proceeding in which the facts of the case were not discussed yet. The Welser case has not begun yet, and the Fuggers case has just started. And thus, we cannot know for certainty whether or not the facts overlap. Moving on to the second point raised by the respectful counsel for the respondent, such an overlap, and they argue, shows an obvious lack of impartiality. Again, if the respondent is arguing that there's an obvious lack of impartiality, they're favoring themselves toward the least, the lower standard under which an arbitrator should be subject to a challenge. These standards are of a third party's point of view and reasonableness and an appearance of bias. So, as Professor Dale has discussed, there are three generations and three ways in which we can look into the term manifest. It appears that the respectful respondent argues that what must be manifest within a case is the facts. And for the facts to be manifest is enough for an arbitrator to be challenged. The facts of this case are not manifest. If we put before a reasonable third party of the sorts, The fact that the Wassers and the Fugers are two banking families within the same country, they have been in communications and in business dealings with the same respondent, but we are unsure as to what exactly they're bringing before the tribunal, and we are unsure as to what exactly it is that will be discussed in the proceedings, and we're unsure as to what legal matters are going to be discussed and what factual matters will be brought up. This does not hold up to the scrutiny of the high manifest lack test or the lower test that the respondent appears to be leaning towards. In this regard, we have to put a link between our argument for the standards and the look we have had to the facts of the case specifically. Under the high standards, there has to be proof that there will be, in fact, a high potential for the arbitrator's state of mind, which is, I must add, within itself a concept that is yet to be grasped by humanity. What is the arbitrator's state of mind? How should we know that an arbitrator feels impartial or feels biased within its state of mind? The facts must be manifest. They must be 100% or at least close to it, and they must directly point to an arbitrator's impartiality. The counsel for the respondents brings up a test which we assume is the test under which the Karatub versus Kazakhstan case was decided, because the respondent said that there's significant overlap of the facts, and second, that the relevance of this overlap is obvious to the eye and visible to a third party without any other information. This specific case, the Karatub versus Kazakhstan case, and the standards set by this specific case, which has been one that has been used in other tribunals, such as the Blue Bank case or the recent Antalya versus Georgia case, was a case in which the disputes had progressed. And thus, all in all, we must argue that Mr. Kujas is in fact not impartial. In fact, man must not be subject to the scrutiny. And lastly, a de facto consolidation is the way. Consent is a matter to be discussed within international arbitration. And all in all, this arbitrator must not be set to the side. If I am of any further assistance to this respectful tribunal,
I don't know whether my co-arbitrator has any questions.
I have no questions at this point.
Thank you very much. Then we'll go on.
I am so sorry. It appears that I had a slight delay in my pleadings. If I am of any further assistance or if there's need for me to repeat my last bit of arguments, I am available to the tribunal. I do apologize for the technical difficulties.
Thank you very much, counsel. I think we actually did catch the last bit up to the point of if there's anything that you could be of assistance. So we believe that we got your arguments. Since my co-arbitrator has no questions at this point, we'll then go on to rebuttals.
Thank you so much. I do apologize again.
Members of the tribunal, just one point in rebuttal. Now, the claimant had earlier tried to say that there was no overlap between the present proceedings and the Welser proceedings because we simply cannot know what the legal issues in the two claims entail. However, we say that this is a disingenuous and untenable position for the claimants to take because they clearly don't believe in it. Now, at page 17 of the case study, in the claimants' memorial themselves, they state, and I quote, "This will in particular help the claimants show that discrimination they have suffered in addition to all other breaches that all claimants in the separate proceedings have suffered." We say that this clearly betrays their true assessment of the situation. Unless this tribunal has any more concerns. This concludes our case on the issue of the challenge to Mr. Kujas.
Thank you very much, Respondents' Counsel. Claimants?
Thank you, Madam President. Members of the tribunal, in line with our efforts to be not a disingenuous party, as the counsel for the respondent argues, we say that yes, this statement could be read as to the claimant's information, as what will be discussed, but the claimant has argued and feels as if it has been discriminated against compared to all parties that the respondent has had dealings with, not just the Welsers. And this is a claim that the claimant feels as if it could have potentially some merit if the Welser and the Fugger case are in fact consolidated in a de facto consolidation. If that is all, and if there are no questions, and if I am of no further assistance to this tribunal, I rest my case. Thank you so much.
Thank you to counsel on both sides. I would just ask my co-arbitrator, Ms. Hanaka, have you heard anything that would change our discussions based on the written submissions prior to this oral hearing?
No, I haven't.
Thank you very much. In that case, the tribunal, having reviewed the written submissions on the challenge prior to this hearing, and having listened to the parties on both sides, have not changed the position initially, which we had initially made, which is that the challenge to the arbitrator is unmeritorious, and we dismiss the that challenge, and we'll now proceed with the full hearing. So with that, I welcome my co-arbitrator, the third member of the panel, back onto the panel, and she will now be able to fully participate in the proceedings with us.
I'm very relieved and happy to reiterate my impartiality and independence with the qualification that in real life, the decision probably would have gone the other way.
Thank you very much. So can we now proceed in line with the guides that the Secretariat had put? I believe that the claimants are taking issue 1. Yes. I'm sorry, you can't hear me.
No, we can't hear the claimant.
Counsel.
My apologies,
the claimant
Madam
is
President.
muted. Okay.
Thank you. Madam President, honorable members of the tribunal, good day. It is my honor and privilege to be here today before this respectful tribunal. My name is Amir Mahdi Dehkhan, as it was mentioned. Along with my co-counsels, we will be representing the claimants on this session of the tribunal. And in the next 9 minutes, I'll be covering issue 1 on behalf of the Fuggers, George, Raymond, and Christopher, the claimants. Members of the tribunal, issue 1 is concerning whether the Fugger loans could be protected under the CCC and exit additional facility rules as protected investments. With regard to this question, I will make a twofold submission. Firstly, the granted loans fall within the definition of investments under the Constitutio Commercialis Carolina, CCC Article 1.6. And secondly, there has been investments within the meaning of exit additional facility rules, and also the Fugger loans can fulfill the requirements of Salini criteria, even the tribunal wish to apply these tests. To proceed on my first submission, I must mention this reality that the investments of capital takes a multitude of forms, and definition of investments in treaties tend to be broad and open-ended. The purpose of ratifying the CCC in 1530 was to provide maximum protection for investors and to liberalize the investment and trade. mentioned on the preamble of the CCC, and that was the reason why the Fuggers was one of the strong supporters of the CCC in time of its ratification, mentioned on page 4 of the case at hand. Members of the tribunal, with regard to Article 1.6 of the CCC, there has been various grounds which implies the loans as protected investments. Firstly, the definition of investment in this article is open, general, and not restricted, as it is stated in the case of RREEF versus Spain, which was held under the Energy Charter Treaty, a modern version of the CCC with exact wording of the Article 1.6, in which the tribunal held that the definition of investment in this article is open, general, and not restricted. Also, in the case of UCAS versus Russia, the tribunal held that the definition of investment in this article, which was the Article Energy Charter Treaty, which for the purposes of page 1 was the modern version of the CCC, the tribunal in this case indeed also held that the lists of the investments in these Article 1.6 is not exhaustive. Secondly,
so, Counsel, before you keep going on Article 1.6, you made a reference to the preamble, which says that the whole purpose of the CCC is to catalyze economic growth by means of measures to liberalize investment and trade. At a big picture level, what does that have to do with your clients making loans to royalty who are waging war with disastrous economic and trade consequences?
Madam Arbitrator, would you please clarify your question?
How can, if we look at the preamble, which says that the whole point of this investment treaty, like all investment treaties, is to promote investment and trade between states, investors and states, how can a loan to an royalty who needs the money to wage war, which always damages economies, fit as a general matter under the umbrella of this treaty?
Madam Arbitrator, actually the loans, however, not all of them were paid for the war purposes. For instance, in the page 10 of the case at hand, apologies, in the page 7 of the case at hand, when Spain was in financial difficulties and he couldn't able to pay its debts, actually he tried to require more loans from the Fugger. Therefore, all loans were not for war purposes. Even the loans for war purposes, as we know, this security is a basic level for the economic growth. If there is war or chaos in the society, therefore there would be no basis for economic prosperity.
Thank you, Counsel.
Moreover,
before you go on, may I ask something? You were discussing Article 1.6 before, and I understand you emphasized the non-exhaustive nature of that definition, the breadth of the definition. Is it your position that the investments at issue in our case don't fall within any of the categories listed in Article 1.6?
Thank you for your question, Madam Arbitrator. Indeed, it was my first ground, a general one, but secondly, I was about to mention that on the paragraph C, it states that claims to money and claims to performance pursuant to contract having an economic value and associated with an investment is regarded as actually protected investments. In the case of TEDx versus Venezuela, the tribunal held that every kind of asset, including claims to money and loans for the purposes of this article, are protected investments, which has got a similar wording like the paragraph C of Article 1.6. Moreover, on the last paragraph, it is stated that in the a change in form in which the assets are investments does not affect the character as investments. That's why we firstly argue that the definition is broad and open and not restricted, And on the second place, for the purposes of paragraph C, the Fugger loans should be regarded as protected investments.
Thank you. Could you elaborate a little bit on the express requirement associated with an investment in literacy? You explain its claims to money or claims to performance. How are the claims at issue here associated with an investment?
Madam Arbitrator, actually, from the Maximilian and Charles V time to this Penn default in 1557, there has been a chain of loans, a chain of lease of revenues, which are connected together. In each chaos, in each war, in each financial difficulties, the Spain or the Holy Roman Empire required more money, and the Fugger obliged. They was due to each other, and they were as a chain of loans. That's what's be proposed.
Counsel, I can understand the chain of money, and I can understand the loans consolidated. What I would like, and I believe that's what my co-arbitrator wants clarification about, is I would like the linkage between the loans and the investment. What is the investment?
Madam President, for the purposes of the definition of investment in these regards, it is our understanding that each of loans are regarded as investments per se, and because there has been a chain of loans, they are together with each other. But there has been another ground for being associated, if that's when the Fuggers paid loan to the emperor or to the Spain, but they could not able to pay these loans back, and for the purposes of these disability, they are required more loans to pay the previous loans. That's why we argue that this is resembles the situation as a chain of loans, which are connected together. Madam President, as I see I'm running out of time, with your permission, if it is possible, I require 1 minute to conclude my second submission and a brief conclusion of my whole submissions, if it is possible.
Please proceed. We did interrupt you.
Thank you. To proceed on my second submission, firstly, for the purposes of Article 3 of Additional Facility Rules, the provisions of the exit convention are not applied. Therefore, it is the claimant's submission that the Salini test should not be applicable for the purposes of dispute, even if the tribunal wants to adopt these tests. Therefore, all requirements are fulfilled, including contribution to money, duration, investment risk, and contribution to economic development of the host states. All in all, members of the tribunal, it is the claimant's submission that for the purposes of the loans, Fugger loans being regarded as the protected investments under the CCC and Salini criteria, even if it is applicable, this tribunal has jurisdiction ratio materia with regard to these loans. Unless I may be of further assistance to the tribunal, that concludes my submissions.
Thank you very much. I don't know if any of my co-arbitrators have any other questions.
No, thank you.
In which case, thank you. In which case, I would ask counsel for the respondents to proceed.
Good day, Madam President and members of the tribunal. As earlier introduced, my name is Justin Lai, and I act as counsel for the respondent. I'll be now taking 10 minutes to go through issue 1 regarding the jurisdiction rationale material of this tribunal. It is our position that this tribunal does not have jurisdiction rationale material, and we have 2 submissions to make in this regard. My first submission is that the loans do not fulfill the definition of an investment within the relevant investment treaty, the CCC. My second submission is that the loans also do not fulfill the objective criteria embodied within the Salini test. Turning now to my first submission, we submit that the loans to the emperor do not satisfy the definition of an investment within the CCC And I kindly request this tribunal to turn to Article 1.6, which defines the term investment. Article 1.6 defines an investment as, I quote, every kind of asset owned or controlled by an investor, followed by a list of examples from A to F. Given the existence of the list of examples, parties must have intended to limit the scope of investment to some extent. And the list of examples here is in pari materia to the list of examples in the Energy Charter Treaty, hereinafter ECT. In the ECT, this list of examples was subject to extensive renegotiations and kept changing throughout the entirety of the 100 drafts of the ECT. Now, if these examples were merely illustrative, there would have been no point for parties to engage in such extensive negotiations. The relevant example here is Article 1.6c, which requires that claims to money be associated with an investment. And as Madam Anneke earlier queried counsel for the claimant, this requirement of being associated with an investment, and it is our position that it has not been met in the present case. As stated in the PCA case of UCO's investment. And as Madam President earlier queried the counsel for the claimant on whether the link between the loans could qualify as being this separate investment, we say that such an interpretation is clearly untenable and flies.
Counsel, if these loans, extensive loans necessary to keep your government and your king afloat are not investments for purposes of the treaty, what exactly were they?
Madam Reid, we would respectfully disagree with the characterization that these loans were necessary to keep our government afloat. There were many other creditors, such as the Genoese and the Welser, who also extended such loans to us, and we would characterize such loans as a simple one-off commercial transaction. And this is because the loans were given in order for the emperor to pay his debt or to use it however he saw fit, and there is no investment risk associated with them, which is also a point that I will touch on later. And furthermore, members of the tribunal, counsel for the claimant has neglected to mention a further requirement in Article 1.6 of the CCC. If you could turn to the very last line under Article 1.6, it states, I quote, investment refers to any investment associated with an economic activity. Now here, there is clearly no economic activity as this requirement in Article 1.6 is also not satisfied. And therefore, on this basis, we will argue that these loans do not constitute investments within Article 1.6 of the CCC. I now move on to my second submission, which is that the word investment in the ICSID additional facility rules has an inherent meaning, and criteria such as the Salini test must